What if I told you a man died during an intimate moment at work, and a Chinese court ruled it a workplace accident? Welcome to 2230, where we unpack the most unexpected stories shaping our world. Today, we're diving into a case that challenges our understanding of work-life boundaries, labor rights, and the legal definitions of workplace accidents. In October 2014, a security guard in his 60s, referred to as Mr. Zhang, was on a 24-hour shift at a shuttered wool factory in Beijing's Shini district. As the sole guard, his duties required him to remain on-site continuously, with the guardroom serving as both his workplace and living quarters. Around noon, Mr. Zhang invited his girlfriend to the guardroom. During their intimate encounter, he suffered a sudden cardiac arrest and passed away. Police investigations confirmed the cause of death and ruled out any foul play. In December 2015, Mr. Zhang's son applied to the Municipal Human Resources and Social Security Bureau to classify his father's death as a work-related injury. Under China's work injury regulations, deaths due to sudden illness at the workplace during working hours can be treated as industrial accidents. However, the Bureau denied the request, arguing that Mr. Zhang died while engaging in a personal non-work-related activity. Unconvinced, Mr. Zhang's son filed a lawsuit against both the Bureau and the security company. He argued that his father had no opportunity to leave his post, and since the guardroom also served as his living quarters, any personal activity had to take place there. He stated that rest is a worker's right, and romantic interaction should be considered a form of psychological and physical recovery, similar to eating or sleeping. The court ruled in favor of Mr. Zhang's son, determining that his father's sudden death qualified as a work-related injury. Since the death occurred during working hours and at the workplace, it fulfilled the legal conditions for a presumptive industrial accident. Although the security company and the Bureau filed an appeal, the court upheld the original verdict, affirming that Mr. Zhang's 24-hour duty arrangement left no separation between his work and personal life. On February 24, 2017, the Bureau complied with the ruling and issued an official certificate formally recognizing Mr. Zhang's death as a workplace-related incident. This case sets a precedent in the interpretation of work injury law under exceptional job conditions. It raises important questions. How do we define the boundaries between work and personal life, especially when the workplace doubles as living quarters? Should personal activities conducted during work hours in such settings be considered part of the job? We'd love to hear your thoughts. Do you agree with the court's decision? Should employers be held accountable for such incidents? Share your opinions in the comments below. If you found this discussion thought-provoking, please like, share, and subscribe to 2230 for more in-depth analyses of unusual and impactful stories.